you're Byron Morris,
Yes, ma'am.
and Mr. Morris was previously in court. Hold on a second. Let me find it.
So we need to proceed on the MTRP.
Right. He's already in. That's what I'm looking for. All right. So, Mr. Morris, you were previously in court in cause number 15-21651, entered pleas of true to counts 2, 3, and 4 in a motion to revoke your unadjudicated probation. I have received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have none.
Yes, ma'am.
Any additions or corrections to that report?
No, Your Honor.
And this was an unagreed. And so count 1 alleges that there was a new offense, which is the indicted case of aggravated assault with a deadly weapon. And we set this for a hearing. What is the state's position on count 1?
Judge, I have made repeated attempts. I was out this past week, but I made attempts the week before that and the week before that. Have called the complaining witness at every number I have for her. Nobody answers. One is restricted. One is not her number any longer. I've also tried to contact the eyewitness. Had 2 phone numbers for her. One wasn't accepting calls. One was not in service. I had tried to get a hold of the detective in the case to get him to try to help me contact these people. I've got with one of our investigators. We have had no success in locating them at this time. So we made great due diligence to try to get them here to prove this up for this hearing.
All right, then it looks like count 1 will be found not true. On probation for burglary of a habitation is a deferred probation. Mr. Rojas, you may proceed.
Hey, Judge, Mr. Morris is going to be asking to be reinstated, Judge, and you look at the allegations that he put through, they're basically their administrative violations. The first one, he didn't have suitable employment. Previously, he was working at the city sewer department, and he was diagnosed with seizures, so he lost his job. He couldn't continue that job. He's thinking now that, and he continues to have seizures. He's on medications at the jail, and he's thinking now that he's going to have to apply for some kind of disability if he's able to be from custody. And obviously, that goes to count 3. If you don't have a job, you can't pay your money. He's behind on the fees and costs. As far as count 2, he did not report his arrest until he was not aware he was supposed to report his arrest, but in any event, he did not report that arrest. Note that he has been to safety, successfully completed safety and the aftercare program. Shows me a willingness to better his life, to make improvements in his life, and that's what he's asking me to do, Judge. He has shown the ability to follow the rules as far as safety is concerned. And it doesn't look like there's any other violations other than not having a job and being behind. So he's asking for another shot at probation, to remain on probation, hopefully get approved for disability, find some kind of employment that will help him get caught up on probation fees, and move on with his life. At the appropriate time, we'd like to say something about that.
Go ahead, Mr. Morris.
It's been kind of hard for me these last couple of years.
I'm sorry.
Been kind of hard for me these last couple of years after I lost my mom and dad. At 23, after my mom and dad, I was diagnosed with these seizures and I lost my job. It's been hard to find employment because I got to get cleared from a neurologist first before I can find any employment. So it's just hard.
So let me ask you this. I know the complaining witness is not being cooperative, but what's your relationship at this point, if you're released, with Taquana Johnson?
Not whatsoever.
Okay. Mr. Smith?
Judge, I'll bring your attention back in 2016 when he originally pled. This was not a plea for probation. This was a cap plea. The court granted him probation. This is not the first MTRP that we've had. We've sent him to safety relapse. Still not in compliance. There's always an excuse. He does work. He's got a job, but he's not paying his fees. Oh, there are technical. It does show a consistent history of not following the terms and conditions of probation. We feel like, as the probation department states, he's been given multiple opportunities to correct his behavior. and probation has exhausted all appropriate sanctions in this case.
Well, I mean, the fact that we don't have count one, obviously there's an issue with employment and pay and fees, not reporting that arrest. There are some positives that I see in that after safety relapse, there haven't been any positive drug screens. And so it looks like that part of his life has been at least.
Right here, everything hangs in the balance. 3 violations on the table. A history that's not helping and a judge weighing whether this is a setback. Or the final straw that sends him to prison interview.
At least for the time being addressed. How long have you been in custody on this motion?
This is January on. I first came back in October.
All right. I mean, I don't think those 3 things, obviously there's been some history and prior motions, but those 3 administrative violations, I don't think warrant going to prison after he has been successful after Safe P. Here's the thing, Mr. Morris, I don't really disagree with what Mr. Smith is saying at all. You were lucky to get your probation in the first place, and then you've had a couple of opportunities on that. I don't know what happened on the day that you were arrested, but she's obviously not cooperating, and so there's nothing that I can do about that. I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to continue on probation. Allow the time that you've been in custody to serve as a sanction, but I'm also going to amend the conditions of your probation. You are, no matter what, to have absolutely no contact, no communication at all with Taquana Johnson. She cannot give you permission to violate that. So she can't say, hey, it's okay, let's get back together and whatever. It'll be a violation of your probation. If you have some actual medical issues going on, then I'm going to order you to get that documentation to your probation officer within 1 week of your release from custody, because they need to know, though. You can't just say, I've got a medical issue, so I can't work, or I can't do this or that. If you're not working, there's probably some community service you can be doing. But if you're working on disability, you need to get that to your probation officer, not just verbally, documentation of going to the doctor, what the diagnosis is, and those types of things. And then we can kind of go forward from that way. If there's anything that can be transferred fee-wise to community service that he can complete, you can do it that way, and that way it'll take care of some of those fees and fines. Probation can do that. And so this is it, though. If you're back in here in front of me, Mr. Smith will remind me of all the chances, and I'll probably go back and wonder why I did this at that point. And you're looking at going to prison for up to 20 years. All right. So don't put me in that position to regret what I'm doing right now. This was not a plea agreement. You have some rights to appeal. If you'll sign that with him, get him the bottom copy. And then just when you get out, first thing you do is go back to probation. Make sure you follow all those rules.
Yes, ma'am.
And so what's the set? Do we need to reset the other case, or? So the other case, the new case, is still pending. It has not been dismissed. I would ask at that point on the next setting for you to try to issue a subpoena. Let's figure it out one way or the other on that first court date. So it'll be reset. So you'll need to make sure and stay in touch with Mr. Rojas, stay in touch with probation. They'll let you know when that next court date is.
Yes, ma'am.
Okay.
One last chance, that's what the judge just gave him. No contact, strict rules, and 0 excuses left. Next time he walks into this courtroom, it won't be for probation, it could be for 20 years behind bars.